This is LXBN TV, and I'm Colin O'Keefe. Last week, a class action lawsuit was filed against LinkedIn for a data breach affecting 6.5 million users. This coming less than 10 days after the breach took place. To discuss the case, we bring in Saikali, partner with Shook Hardy and Bacon, and author on the Data Security Law Journal. Al, starting off, can you give me the details of the lawsuit? Who are the plaintiffs, and what are the allegations against LinkedIn?
Right. Well, as you mentioned, Colin, LinkedIn did recently suffer a data breach that exposed potentially up to 6.5 million of its users' passwords. And then approximately 10 days later, a class action lawsuit was filed against LinkedIn by two classes of plaintiffs. One class of plaintiffs is comprised of any individual or entity in the United States who had a LinkedIn account on or before June 6, 2012. That's the date when the breach was announced. The second class of plaintiffs is comprised of anyone in Class 1 who had paid a monthly fee for an upgraded account because LinkedIn charges for certain upgraded services. Essentially, the plaintiffs allege that LinkedIn failed to follow certain standard industry protocols in securing the user's passwords, and specifically, they make three specific allegations. First, that LinkedIn failed to do what's called salting the password, and what that means is basically adding random values to a password before it's stored. So, for example, if your password was Miami, the password as it would stored would be M648I, you know what, and it breaks it up into little pieces. Mm-hmm. Then the other thing they claim that the plaintiffs claim that LinkedIn failed to do was store the information in a hashed format. What that means is instead of storing it as Miami, well, usually what you would try to do in a hash format is store it as, instead of Miami, you would have 6 number signs. Mm-hmm. So you don't actually see the word Miami on it. Or they would hash a portion of it, so it would be MI and then 4 number signs. Instead, the plaintiffs allege that LinkedIn didn't do that. And then the third thing they claim that LinkedIn didn't do is store the passwords on a separate secure server.
Mm-hmm. I see. And in cases like this, don't the plaintiffs have to show that the breach caused actual harm? Because I saw that, despite the breach, that people got a whole number of passwords, there weren't many, if any, accounts that were actually compromised. So what are the damages that the plaintiffs are claiming in this case?
That's right. And it almost always, plaintiffs do have to prove some sort of actual harm. And I can cite to you several cases where plaintiffs in these data breach cases have lost, either on dismissal or summary judgment, as a result of not being able to show some sort of cognizable harm. And examples of cognizable harm in other cases where courts have allowed the lawsuits to proceed have included things like fraud on your credit card. So, for example, there's a data breach and a consumer's credit card information is exposed. In an instance like that, if the credit card is used fraudulently, then any sort of cost that the consumer incurs as a result of fraudulent charges or replacing the credit card or purchasing credit monitoring or credit insurance, those would be sort of actual harm, according to some courts who have ruled on this issue. So that would traditionally be the type of harm, and it's questionable as to whether that exists in this instance, certainly with the first class and perhaps even with the second class.
Mm-hmm. And then, and finally, doing a bit of forecasting, in what direction do you see this case heading? Do the plaintiffs have some real ground to stand on, or will the primary outcome of this lawsuit be, maybe just getting the FTC's attention?
Right. Well, it's still really too early to tell, Colin, because the lawsuit's just been filed, and all we have so far is the plaintiff's version of events. We haven't heard from LinkedIn. We don't know what security measures LinkedIn actually did take to protect the information. We don't even know if the plaintiff's allegations are correct. So it's tough to sort of gameplay, what's going to happen moving forward. I know that the key in these type of cases, there are really two main issues. One is what we've touched on, which is what harm has the plaintiffs suffered. And then the second key issue is legal defensibility, which means what steps did LinkedIn take before the data breach occurred to protect their customers' information. Now, I think that there is a chance that here, when you ask yourself what is going to be the cognizable harm with respect to the first class, it's going to be difficult to show that they suffered a cognizable harm. That first class, remember, is anybody who didn't purchase the spend money on the upgraded form of LinkedIn. The second class did seem to spend some money on the services provided by LinkedIn. I think also you might see some reliance by that first class on a recent case called Claridge versus RockU. There, a court determined that just providing personal information to a service provider, that personal information is a form of currency. And so when there's a data breach, that currency actually has a diminished value, and that is a cognizable harm, said the court in RockU. That is the only case I've seen that's held that, but it's still good law, at least as of now. So it'll be interesting to see how these issues develop. With respect to the FTC, I'm sure that given the high-profile nature of this data breach, the FTC, this is already on the FTC's radar. I often counsel my clients to work proactively with the FTC when they suffer a data breach, because the FTC likes to see that you're working with them, sometimes voluntarily disclosing information up front before the FTC has to ask for it is a good move. So I suspect that's probably already in the works.
Mm-hmm. Well, this is going to be interesting to watch, particularly one of the points you made in there. We're always told with sites like Facebook, Google, those types of things, we're not paying for them with currency, but we are paying for them with our personal information. It's going to be interesting to see how the courts weigh what we've kind of not been told, but always kind of understood how we pay for these services. So that'll be interesting to watch. Well, once again, that was Al Saikali of Shook, Hardy, and Bacon and the Data Security Law Journal. For more on this story, be sure to visit his publication. It's at datasecurity.lawjournal.com. And for more LXPN TV interviews, visit us at lxpn.lexblog.com. Thanks, Al.
Thanks, Colin. Take care.